Okay, Mr. Barnett, how are you doing?
Good morning, Your Honor. I'm doing well. How are you?
Good. Mr. Lupton, is that how you say it? You're on mute. We can't hear you. You got to push the unmute button.
Yeah. Can you hear me now?
Okay. Yeah, that's fine. I can hear you. So you say it
Okay, thank
Lupton?
Yes, Lupton.
Okay, fine. Mr. Barnett, when we met on the 6th of October, were you part of this hearing?
I'm trying to think of the
It
last
was when
three.
the plaintiff's attorney did not appear.
Yes.
Okay. And I believe I made a phone call. I don't know if I made the phone call while you were on the record with the Zoom. We were trying to figure out why nobody had Zoomed in. And then I got through, I think, to an attorney by the last name of Cox, C-O-X. Does that ring a bell?
That's who I've been speaking with, is Attorney
Okay.
Cox.
So on this case, have you been talking? Are you guys connected to each other right now? You
No.
and Mr. Lupton? We're getting a feed. We're
Yeah.
getting a feedback. If you have another device open,
You want to try muting yourself, Chuck?
Yeah. I can-
okay. So what I was wondering is, like, have you had any connection to the plaintiff's attorney since the last time that this was set for a summary disposition?
No, I had previous to that hearing when he didn't show. I have not heard from
Okay.
him since.
That's odd. Okay, well, that's, to me, the second time that they haven't appeared. Really, all I'm going to do is just deny the motion for summary disposition. I don't have really the wherewithal to dismiss the case entirely. Who is it? My clerk's telling me he's zooming in right now.
Okay, great.
Okay, Mr. Cox, we've been waiting for you.
I appreciate that. Good morning.
Morning. I thought we were going to do a repeat of last 2 weeks ago because we had this motion for summary disposition you filed set for the 6th of October and no one appeared from your office. And then I felt like it was happening again this morning since the last 5 minutes. I was talking to Attorney Barnett about whether he'd had any connections with you. He's indicated that since that date, you guys haven't talked at all. And you're here for the motion today. Why don't you state what you want to say, Mr. Cox, on this file against Mr. Charles Lupton? And then I'll let Mr. Barnett speak.
Yeah, Judge, good morning. Yeah, I apologize again, a little connection issue. I did connect last time at around 8:33, 8:34, and the court actually adjourned the matter on the basis that counsel had yet to file an appearance or response to the motion. And I'm not sure if that's still the case. Did that get resolved? Because I don't know that we ever got a response to the motion.
My recollection was, go ahead, Mr. Barnett.
I have filed an appearance, but Mr. Cox, I don't have your motion. So, and I did address that with the court last week because I don't have your motion yet, so I can't respond without your motion.
Well, all I'm saying is the last time, and it may have been a late call-in, maybe like this morning. My memory is I contacted your office, Mr. Cox, because I was looking for Schlesinger. And
Judge,
then I found out.
I did Zoom last time, Judge, and I have my notes right here, and I recall because it was about
I'm not
8:30
doubting that you zoomed
Okay.
in.
Yeah,
I'm not doubting that you zoomed in late. My recollection is that I made the call to your office at the time when the Zoom was ordered to be held. At any rate, really, we're not back to where we were. I'll just let you orally say what your position is. If you didn't know that Mr. Barnett was part of the case at that time, that's probably why he doesn't have any of the paperwork on your motion. But let's just have you state what your position is, Mr. Cox, and then let him respond orally.
well, yeah, Judge, I mean, on this one, it's, and I know the court has has seen a lot of these different cases, and obviously it's plaintiff's position that it's entitled to recovery for the outstanding dues owed by Mr. Lupton in this case. We haven't seen a letter from Mr. Lupton. I think the allegation is that he opted out, but we've not seen a letter from him that represents that he did so in writing. We attached a copy of the actual contract that he has signed that indicates that he was in the union. He hasn't opted out. We don't have a response to our motion. I know, actually, I think what happened on this one, Judge, if my recollection was correct, is that counsel, in the midst of oral argument on this motion, intervened and indicated he wished to step in and represent Mr. Lupton.
Okay, I remember that for sure.
Okay. And then I think what happened then was we adjourned that motion out to the last hearing date, but yet still the counsel didn't really get involved. I don't think he didn't file an appearance until recently. He didn't file a response to the motion. So this is actually technically the third motion date set for this, hearing date set for this motion, and we still don't have a response in from Mr. Lupton. And so I appreciate there's been a little bit of disjointedness, but at some point, I think we do have to take a look procedurally at how this case is proceeding with regards to response to our motion. I know counsel had indicated sort of abruptly at the first hearing, this is exactly like the other hearing that I was representing another client on that the MEA had brought a claim against. But we don't really see it that way. And I guess not having a written response to the motion makes it difficult for me to sort of address the various issues that may or may not be being raised. Defendant in this case, defendant paid for 1 year after right to work. So I know in some of the other cases, people think that they were opted out of the union just because they stopped paying, or because right to work was passed. But in this case, Mr. Lupton actually did pay for 1 year after right to work was enacted. So, a lot of cases, Judge, we see that, they stop taking money out of people's checks. And so they think, well, I'm out of the union, or I think right to work passed, so I'm out of the union. But Mr. Lupton actually affirmatively made payments for the first year after right to work was passed. And so I don't think he can make the argument that he didn't know that he was still in the union after right to work passed. I don't think he can make the argument that, hey, they stopped taking money out of my check, so I didn't have to pay anymore, because there he was paying for a full year. So I think this case is distinct from some of the other ones that this court has heard. And I think it's distinct from the one that Brother Counsel had represented another client on. It's difficult because, again, we're sort of flying blind on this with regards to what the defenses are for me to address them.
When did you become aware that Mr. Barnett was an attorney of record?
Well, I'll say this. I was aware that he was attending to file an appearance at the 2 hearings ago. So that would have been.
Okay, but fair enough. I get the disjointedness that you discussed, and there's probably several areas that are disjointed. But I'm just wondering, have you ever sent the motion for summary disposition to Attorney Barnett directly?
Let me look. I thought I emailed it to him, but I will take a look here.
And then while you're checking.
Yeah, go ahead.
Go ahead. Because really, I get the arguments you're making, and you've repeated them several times, so it's clear what your position is, that this case isn't like every other case, and he might have thought he opted out, but he didn't have anything in writing. You've never seen anything in writing, paid union dues for a year. And at the October 6th hearing, there was discussion about the defendant trying to cancel and that he was told his membership was inactive. I don't know exactly the timing of all of that, but that was part of the argument that the defense made. Having said that, if the plaintiff is aware, and really this Schlesinger attorney's not with your office anymore, correct?
That's correct. He opened a probate practice.
So do all the cases we have with his name on it just stay that way? Or is there a substitution that occurs?
Attorney Susan Winters is filing appearances on these substitutions of attorneys. Our office is
Okay.
representing the MEA.
And is Susan Winters with your office?
See, Susan Wint, yes, correct. It's Lake and
Okay.
Ingber and Winters, or excuse me, Ingber and Winters.
Okay.
She's the Winters and Ingber and Winters.
All right, I got you.
And Mr.
So,
Barnett,
if-
oh, I'm sorry.
Go ahead.
I see an email. Mr. Barnett did email me on October 2nd. And he attached an opt-out letter, but it is not signed by anybody, and it is one sentence, and I don't know where it was sent. So
Right, but I'm more interested in whether you ever sent him a copy of your motion for summary disposition. All right, let me just have Mr. Barnett speak, and then if there's anything further you want to say, Mr. Cox, you can. Go ahead, Mr.
Very good.
Barnett.
Thank you, Your Honor. No, I have not received a copy of the motion. I do remember at the last hearing, when Mr. Cox was late, that you had said, well, maybe it's because you haven't filed an appearance yet. So I did file an appearance after that, sent a copy to Mr. Cox, but I haven't received anything since then. I'm happy to do my best at oral argument today, but again, since I don't have a copy of their motion, it would be tough for me. The one thing that I did do is as Mr. Cox just mentioned, I did send what I believe would be a genuine issue of material fact, which is Mr. Lupton's letter to the MEA at 1129 Bridge Street in Belding, asking him to end his membership on 11/14/2014.
Uh-huh. Okay, and how do you respond as it relates to anything with reference to Mr. Cox's argument that your client paid union dues for a year after the
Sure.
right to, go ahead.
Sure. Thank you, Your Honor. I don't think that really changes anything because he didn't sign a new contract. So the arguments that I had argued at the last hearing, being that the contract was then invalid once right to work passed as contrary to Michigan law, I would imagine still apply. Again, I haven't seen Mr. Lupton's contract because I don't have a copy of the motion, but if it's similar to the other ones I've seen, then I think we still have that exact same argument that it's contrary to Michigan law. Unless he signed a new contract, which I am unaware of, then that would not change. The fact that he paid on his credit card for a year after wouldn't change anything. He didn't sign anything new. He just authorized payment for a year, and then he sent in a letter in 2014 that said, "Okay, I'm done. Please rescind my, please end my membership."
All right. Anything else that you can think of that you want to say, Mr. Barnett?
No, Your Honor.
All right. Mr. Cox, anything final that you want to say?
Yeah, Judge, I don't know. I mean, I'm looking through to whether we actually got him a copy of this motion or not. I don't know. I'm a little bit frustrated that counsel can appear twice on this, never have asked for our motion. I don't see any request that he ever made to get it. I knew he knew about this motion since early September, and he's coming before the court now with kind of his arms folded saying, I can't respond properly because I don't have your motion, and it's all on plaintiff to have provided it to me because I filed an appearance. And I get that, but it's a little bit frustrating from plaintiff's perspective, as this to say this is all on the plaintiff when he's the one that jumped in the case in the middle of oral argument two times ago. So I just kind of wanted to state that on the record. I appreciate it. Almost sounds like plaintiff is the bad guy here for not having given him a copy of this motion when it's been served on his client all the way back in August. So I guess I'm frustrated in that regard. But beyond that, I don't think so, Judge. I think we've been kind of waiting for him to engage the case, and I think he's saying effectively it's plaintiff's fault that I can't engage, and I kind of take a little bit of issue with that on that basis. But again,
Okay.
Judge,
Okay, well, let me just say this. Nobody's the bad guy in any of this litigation. All we're trying to do is resolve a dispute.
Yeah,
I don't lay blame to either side, and while the frustrations are there, the frustrations are probably equal. And if I join in, the frustrations are probably
No,
equal three times,
I know,
three
Jeff.
times around. The issue as it relates to, it's not just whether they got a copy of the motion for summary disposition, because I was going forward with it whether he got it or not.
Okay.
I get the point that you're making, Mr. Cox and Mr. Barnett. I'm sure you could have seen a copy of your client's motion for summary disposition, since that's what we were meeting on. My notes reflect that Mr. Cox was late in zooming in, both on the 6th of October and on today. That doesn't make anybody a bad guy. It just is what it is, and it moves us forward to try to see if this dispute can be resolved. My first question to Mr. Barnett before you zoomed in, Mr. Cox, was have there been any communications? Have you talked? Because that's where it has to start.
Yeah.
The two attorneys have to talk to each other about whether this case is worthy to continue or not, whether it can be resolved or not. You can, Mr. Lupton, have a very strong feeling that you don't owe $3,000 to the Michigan Education Association, and you can stand firm on that. But if a case goes to trial and you're found responsible, you could be ordered to pay the $3,000 or more. So you guys have to talk and discuss where it's at. The Michigan Education Association can stand firm in this case, saying this is what's owed, no questions about it. We haven't seen anything. We got some letter, but it's not signed, so I don't know if it's real. You can argue to the nth degree on every one of this from either side. It's not going to get resolved until you actually talk and discuss it at more length. I get that there's shared frustration. I'm not laying blame to anyone. I'm just at this point not willing to grant the motion for summary disposition, only on the premise that the defendant felt that he had canceled, that he was told he had an inactive membership, that the plaintiff's argument is he was paying and had paid for a year and never canceled in writing. If those are the issues, shouldn't be too long of a trial. If you can talk about it ahead of time and discuss it, it needs to come from both ways. There has to be both sides willing to discuss this, not waiting for one to call the other. Right now, all I'm doing is respectfully denying the motion for summary disposition. But I tell you, Mr. Cox, that if the issues as you continue to discuss the case and in any discovery that's done between you and Mr. Barnett with Mr. Lupton's case, you're able to file another motion for summary disposition if you deem it necessary or feel that the facts are presented in such a way that it would make sense. Same with you, Mr. Barnett. I don't stop anyone from pursuing any further actions with this case, but I am asking you both to talk to each other and discuss it at length before we go forward from there. All right, so Mr. Cox, I'll ask you to prepare the order. Right now, it's a respectfully denying the motion for summary disposition. We'll set it up for a pretrial and then a trial. Questions that you have at all, Mr. Cox?
No, Your Honor. I have some settlement authority. I'll get with Brother Counsel and share those, what
That's
I have.
fine.
So we can go with that. No further questions, Judge. I'll submit an order.
Thank you. Mr. Barnett, any other questions you have?
No, Your Honor. Thank you for your patience.
All right, that's it then. Mr. Lupton, you can disengage. Just stay in contact with your attorney. Thank you, gentlemen.
Thank you, Your Honor.
Okay, thank
Have a good
you.
day.
On the phone number that starts with 586, is there anybody with area code 586 that's
Yes.
part of the Zoom right now? Can you
Yes, there
identify
is, Your Honor.
yourself?
Yeah, Your Honor,
just
this is
identify
Attorney
yourself.
Michael Beach, B-E-A-C-H. I'm here
Okay,
for credit
thanks.
acceptance.
Yep, I'm just getting to that one right now, Mr. Beach. Okay, so it's Credit Acceptance Corporation and Jeffrey Philly. And Mr. Philly is here on the Zoom. Mr. Beach, do you have video capacity?
You know, our computers at our work, they have video. There's no, our clients won't let us have video in our work.
Okay, so that's a no. That's a no. That's all I needed to know right now.
Okay.
Let me just talk to Mr. Philly a minute. Mr. Philly, can you hear me?
Yes, ma'am.
Okay, if you're remembering this correctly, this case goes back to a purchase of a 2010 Dodge Journey SUV. Does it ring a bell?
Yes, ma'am.
Okay, our file is D20C00015GC. I'm Judge Sara Smolenski. And Mr. Beach is an attorney that's on the telephone with Zoom right now, Mr. Philly. You're not physically actually able to see him, but he's on the phone. He's filed a motion for summary disposition on this case, where they're looking at trying to collect a little over $17,500 from you on this case. A summary disposition is the plaintiff's attempt to get a judgment without having a trial. I'll let Mr. Beach speak first, Mr. Philly. Listen to what he says, and then I'll let you speak. Are you with me?
Yes, ma'am.
Thank you. Mr. Beach, go ahead.
Yeah, Your Honor, I'm really not going to be arguing my motion. I've gotten directions from Credit Acceptance, and this has been in all their files. They've recently made the decision not to pursue towards judgment any of these files, any of our files. They sort of are wanting to just dismiss the cases. Well, they want to try to get an extension, just have to put the case on like a stay. If we can't stay the cases, they want to dismiss them without prejudice, Your Honor. So
Okay.
that's where I'm sort of stuck at.
Well, it might sound like you're kind of stuck, but it's like the best news ever for Mr. Philly. It's like he just won the lottery. So what we'll do is a dismissal without prejudice. Because
Okay.
a stay is too difficult to keep track of and try to monitor the time. We like to have some movement if the case is open. So a stay is kind of like a delay that creates difficulties when we're reporting to Lansing on our files. So we'll just do
Yeah.
a dismissal without prejudice. But
I
let me
understand,
explain
Judge.
to Mr. Philly. Let
Yes,
me
ma'am.
explain to Mr. Philly, and I wasn't really trying to be funny, Mr. Philly,
That's okay. I'm just
but
gonna,
I haven't really heard a plaintiff's attorney say that, like on a $18,000 case collections matter that they, are just gonna not go forward. So that's why I said it feels like possibly winning the lottery. When I say it like that, I just want to make sure you understand. When I say a dismissal without prejudice, the terminology of that means that the case is over right now, but it does not mean they can't file it again someday in the future. So
Correct.
you need to be aware that right now, it's a dismissal. But I can't give you the language of now and forever over, because without prejudice means that they can refile the case, but they'd have to start at the very beginning. They'd have to give notice to you. They'd have to serve you. You could get legal representation. Everything starts over with the case. Are you with me?
yes, ma'am.
So really, that's where we're at. And Mr. Beach, Attorney Beach, I'll ask you to
Yes.
prepare the dismissal without prejudice order for the court.
Okay. I'll just submit it under the 7-day rule, Judge.
That's fine.
I also like to, I've had a couple of these, few of these, if Mr. Philly wants to call up and discuss a possible resolution, we can still resolve the underlying debt if he wants to call us
Okay.
up and do something like
Right.
that.
What number would he call? Get this down, Mr. Philly. Do you have a pen?
Yes, ma'am. I tried
What
calling.
number would he call, Mr. Beach? Like a direct line number, so he doesn't have to go through 10 minutes of talking.
Yeah, he can go directly to me. I'll give him my extension.
Okay.
It's 586-558-9000, and I'm at
Okay.
extension 113.
113. Do you have it down, Mr. Philly?
Yes, ma'am. 586-558-9000, extension 113.
Right, and his name is Beach, like Sandy Beach. What's your first name, Mr. Beach?
It's Michael.
Michael Beach, Attorney Michael Beach. It's at least worth looking into, Mr. Philly, but you could also seek out your own advice once you talk to them to see what route you wanted to go. Because
Yes, ma'am.
today this will be a dismissal. One other thing I wanted to say is he's filing the order. He'll send it to me. You'll get a copy. If you don't have any objection to it, I sign it within a week, 7 days. I sign it within a week. You'll get a copy of that too.
Okay.
We still have your correct address now, Mr. Philly. The one that we're using is the address on Vale.
That is correct. 3893.
Okay, good enough then. Thank you, gentlemen. Mr. Beach, is that the only one you had this morning?
That is the only one I have, Your Honor.
All right, thank you. You can disconnect. Mr. Philly,
Okay,
thanks for
have a good
zooming
day.
in. You can disconnect too. Okay. Attorney Mites?
Yes, Your Honor.
What case do you have this morning? Is it the Metropolitan Hospital?
That's correct.
Is Gina Thompson here?
Yes, I am.
All right, thank you, Ms. Thompson. This is a motion for summary disposition that's been filed where Metropolitan Hospital was saying that you owe some outstanding medical services, Ms. Thompson. I know last time you indicated that you didn't know what all the bills stood for, or you didn't know what they all represented, all the charges. Our file is D20 C00047GC. Go ahead, Ms. Thompson, you were going to say something?
Yes, I just wanted to say that I had contacted the plaintiff's attorney, Metro's attorney, and tried to make arrangements of a dollar amount with them. I'm not sure. I have been through a lot of treatments recently for chemo and everything, and I don't remember a lot of stuff. So
Yeah, I don't doubt it. Well, you got a lot going on and your health is number one, and that has to be a priority, no doubt. It probably puts all this other stuff on the back burner, no question. And you don't have to be going through chemo to have problems remembering stuff that happened a while back, because that happens to all of us.
correct.
Although I have a couple, yeah, so anyways, let me just have Ms. Mites, do you say it, Mites?
That's right, Your Honor.
Let me have Attorney Mites say what she wants to say, and then I'll let you respond, Ms. Thompson, if there's anything further. Go ahead, Ms. Mites.
Thank you. Plaintiff filed its motion under both MCR 2.116 C9 and C10. Under C9, Your Honor, we'd ask that the court find that the defendants failed to state a valid legal defense. Looking at the defendant's response to the complaint, the defendant asserts just general denials to the allegations and an unawareness of what the charges were for. So for those reasons, we'd ask that the court find the defendant failed to state a valid legal defense. I guess I'll turn to the defendant's last page of the written answer. The last page contains affirmative defenses. However, they're just mere recitals of affirmative defenses. There's no facts to substantiate a valid legal defense in this matter. Some affirmative defenses that are selected on the defendant's last page of the answer are just inapplicable to this matter entirely. For instance, one affirmative defense deals with the repossession of a vehicle. Under C10, Your Honor, plaintiffs attached records, business records in support of the charges for the court's review, as well as the defendant's review. The court has redacted copies of the statements. The statements attached support the dates of service along with the charges associated with the treatment received. And considering the evidence, Your Honor, plaintiffs requesting judgment as a matter of law.
Okay. Ms. Thompson, you can state anything you want to say. At first, the attorney was talking about Michigan court rules when she was numbering like C 116.9. These are court rules that identify avenues to go forward to get a judgment. But she also was indicating, as you heard her, that some of your responses were not applicable to this particular case, but kind of sounded like they might have been from some other case. I don't know if that's part of not remembering stuff, or if you had somebody help you, or you were using copies of other paperwork to file a response. Do you remember?
No, ma'am, I don't.
Okay.
I just called them to make an agreement, the
Sure.
attorney, and they told me they couldn't take it because
Right.
it wasn't what Metro wanted. And
Yeah.
I am on disability.
Right. Well, here's what's going to happen in this case. They shouldn't be able to get your disability, but they should be able to set up a payment plan that will work for you. We don't want a payment plan that's going to cause you to sink your ship, so to speak. But, sometimes it's hard to even get any kind of a payment plan together because there's nothing left to pay. Or you're
Right.
using it all for your bills and you don't have any, usable money each month to get this stuff taken care of. But the judgment is, it's big, but it's not as big as we've seen. But when you owe somebody $3,000, I mean, it's a lot. There's no question about it. And we'd all like to see it, so that you can make payments and get it taken care of. What I do today is I grant the motion for summary disposition, which makes this a judgment. Then you can ask the court, or you can talk with them directly. It'll be a little different than how you were making your phone call already, because now you should be making your phone call right to the attorney. And we'll get her number here in a second. But it's to try to work out if a payment plan that's reasonable, but not overly burdensome. Because if you can't pay it, you can't pay it. Then they've got to figure out other ways to collect it. Do you have a fishing boat on a trailer in your backyard of your house, and then they try to sell it and put the money toward the debt? Do you own a motorcycle? Do you, that kind of thing? They can attach property, and they do when it's a collection where a creditor is going after a debtor. Even if a Visa card, MasterCard, JCPenney, it doesn't matter. If somebody owes somebody money, once they get a judgment, they try to figure out, well, how can we collect it? And what avenue do they have? Well, they can't garnish your disability because that's not, that's exempt from that. But there may be other avenues that you could work out a payment plan. So Ms. Mites, tell me what your telephone number is. Give me 1 second. Ms. Thompson, do you have a pen?
I do.
Okay, get this down because it's going to be important for you to know her name and telephone number. So Ms. Mites, and you can probably see it on the screen, Ms. Thompson, how you spell Mites, M-E-I-T-Z, and
Yeah,
it's Jennifer.
I don't see anything on my screen,
Okay,
but you.
Okay, it's Jennifer, and her last name is Mites, M-E-I-T-Z, and she's the attorney for Metropolitan Hospital. She's
Okay.
one of she's one of a group of attorneys for Metropolitan Hospital. And Ms. Mites, what's the telephone number Ms. Thompson can get you at?
The office number, Ms. Thompson, 616-931-1130. If you'd like to speak with me directly, just ask for me by name and they'll transfer the call.
Okay. Okay, I will do that.
That's the best bet you have, Ms. Thompson, at this point going forward to try to resolve that, okay?
Okay.
All right, that's it on the Metropolitan Hospital Thompson case. Ms. Mites, you get the order in under the 7-day.
I'll do that, Your Honor. Thank you.
Thank you very much for waiting, ladies.
Thank you.
Okay, you bet.
Yep.
Our next file is D20C01662GC. It's the Van Hatten Law Firm with Mr. Keith Essenmacher. Okay, who's Mr. Essenmacher?
I'm Mr. Esmacher, Your Honor.
Okay, thanks for being available. And then with the Van Hatten Law Firm, is it Mr. Van Hatten? Who's representing Van Hatten? Is anybody here for the Van Hatten Law Firm? Okay, so it was a motion for discovery. Let's see. What time is this set for? 9:15? That's why we're early. We're about 10 minutes early, Mr. Essenmacher.
Okay, Your Honor.
It's unusual that the other side wouldn't be there. So give me a minute and let me find out what's going on with them.
No
And
problem.
then talk to- Yep, just hang tight. Okay, Mr. Nicholas, are you there? Okay. Who has the iPhone with the whitish jacket on? Beard, sitting on a couch.
My name's Taurus.
And you spell it T-O-R-R-I-S?
R-I-S.
T-O-R-I-S. And Mr. Torres, what's your first name?
Shane. S-H-A-N-E.
Do you have a pencil with you?
I can get one.
I need to write you down because you're in the wrong Zoom meeting.
Am I?
You're in the wrong Zoom meeting. You're in the courtroom and you're supposed to be with the prosecutor. So let me just give you this number so you can sign in and get to the right spot.
This is where they sent me.
Did you
Sorry.
talk to Mr. Tarango today already?
No, I haven't talked to nobody. This is
Okay,
where
yeah.
I'm in and they sent me here.
Okay, it's a criminal case that you have. And the Zoom meeting number is as follows. 245
245
Yep, 899
Yep.
6670. Mr.
67.
Torres?
Yes.
Yes, 6670. Mr. Torres, the password is the same password you use. Don't say it because we're live streaming right now. It's the same password you use to get into me. Just
Okay.
call that number. We'll send a message over to the prosecutor that you've been with us for a good 20 minutes or longer, and I'll make sure they know that you were in with me, and you'll get over there to talk to him. His name is Tarango, 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 Mr. Felix Tarango, okay?
Okay, thank you.
You bet. Sir with the white hair in the green sweatshirt. Yeah, you have to unmute yourself because I can't hear you. There's a button that says join audio. Or there's a microphone
Okay.
with a line. There you go. Now you got it. What's your last name?
Rickert, Rueckert.
And what was the case you had was a pretrial with the case with the spilling the load?
Yes,
Okay. And when you had your pretrial with the prosecutor, they talked with you about the case. And originally, when you saw the magistrate on this, because it was a misdemeanor for operating without proper vehicle endorsement and spilling a load on the roadway, they gave you a warning on a no carrier name. I'm not sure what that is, something with the U.S. Department of Transportation. But if this is a case that you are just going to handle yourself,
yes, Your Honor.
you got to make the decision how you want to plead, because there's two separate misdemeanors here, Mr. Rueckert. Operating, presumably a truck, I don't know, operating a truck without proper vehicle endorsement and spilling a load on a roadway. Okay, well, they're both misdemeanors. They're up to 93 days in jail. Doesn't mean you get jail. It just means that's the maximum. Up to $500 fine. Court costs on top of that for each one. You have the right to plead guilty or not guilty. You have the right to have a trial in front of a judge or a jury. Have the right to have an attorney. If you could not afford to hire your own attorney, Mr. Rueckert, you could have the attorney appointed to you by the court, and then you'd have to pay the expense of a court-appointed attorney. They indicated after talking with you at the pretrial that if you decided to plead guilty to spilling the load on the roadway case, they'd totally drop the other case of operating without proper vehicle endorsement. Is that what you talked to that prosecutor about?
Yes, Your Honor, it is.
So spilling the load is really the only case you'd be talking about. Still a misdemeanor, just like I said, still the same rights. Your rights would be have a trial, bring in witnesses, cross-examine witnesses, take the stand yourself, be a witness if you wanted to. If you chose not to, your silence cannot be held against you. And you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. So far, can you think of any questions that you have at all, Mr. Rueckert?
Not at this time, Your Honor.
If you go back in time to March 5, this year, March 5, already over 7 months ago, eastbound M6, Kalamazoo Avenue, that location, how do you want to plead to the charge that they call spilling a load on a roadway, or sometimes they call it unsecured load?
I would plead guilty to that, Your Honor.
All right. What are we talking about that was on the truck or in the truck, Mr. Rueckert?
It was a plastic vault that rolled off the back of the trailer when I hit
And is the trailer like a flatbed?
Yes,
Okay. And the plastic roll or ball is like a section of plastic rolled up. Fair?
it's called a vault. It's
VAULT?
yep.
And what's it used for?
They set them in the ground for connections for underground utilities, such as cable or phone.
Right, but is the plastic vault the actual rolled up coil of the wiring?
No, Your Honor, it's a hollow plastic vault we dig it in the ground and it sets flush with the top of the ground.
It's like the base so that the wires can go into it.
Right.
Okay. How big is that? Was it just one vault that came off?
Yes, it was, ma'am.
If you had a yardstick and put it across the dimension of that vault, if I'm saying it right, the circumference, are we talking, 3 to 6 feet across, or what are we talking?
We're talking 30 inches by 24 inches.
Okay. So just say, and you're on M6 when you're pulling your trailer, it's a flatbed, right?
Yes,
And that goes flying off and lands in the median or lands in the ditch or wherever. True?
true.
Did it ever go through anybody's windshield?
No, Your Honor, it did not.
Can you imagine?
I can.
Have you thought about it?
Yes, I have.
I mean, you'd be the one driving it, and people would know Ron Ruckert and say, he's a great guy, and he's been this trucking guy his whole life. He's done a great job. He's a good, hard worker. Can't believe something like this would happen. I'm just saying, Mr. Ruckert, if the thing bounced off your truck trailer and went into the lady behind you's windshield, and she's killed, you'd feel as crappy as you could ever feel.
Correct, Your Honor.
That's a poor way to say it, but you know what I'm trying to say.
Yes, I do.
And I get that you would never intend to do that.
I would
And I
not.
don't know if this is, defective equipment with your strap tie downs, or whether it just wasn't done properly, or the wind gusts are big that day, or your speed is affected by it. But my God, this is something you do all the time, right?
Correct.
So just briefly, how do you think it happened? Why would something like this happen to you when it's not supposed to, and you don't usually let this happen?
It was a strap failure. I hit the bump on the bridge where the bridge starts on Kalamazoo, and I looked in my mirror. I seen it in the shadow on the road that it was falling. I pulled over, turned my emergency flashers on, and pulled over to the edge of the road. It fell off, but I didn't stop there because there was a guardrail and I could not get clearly off the edge of the road far enough.
Right.
So I continued down until the guardrail stopped, went back and retrieved the vault that fell off the truck or trailer and pushed it up the side of the road.
And it's circular, so you could roll it, right?
No, they're square, but it only
Oh.
weighs about 30 pounds. So I
Okay.
was able to push it up the edge of the road.
And it's the only thing that came off your trailer.
Correct.
And it never hit another vehicle.
No, it did not.
Yeah. Okay, now I don't want to be too buggy here, but I'm just wondering, when the state trooper, the DNR guy, or the state MDOT guy, or whatever they call him, gives you the ticket for operating without proper vehicle endorsement, what's that about? I know we're not going there, I just want to know.
The truck that we normally haul that trailer with is an F-250 Ford pickup. It was in the shop, so I used the boss's F-350 Ford pickup, and the GVWR on the 350 is higher than the 250,
Yep.
which put me over the legal limit for
Right.
a chauffeur's
Okay.
license.
Well, what I'm just asking you to do is be more prudent in every way. When you describe the strap failure and the way it bounces on the roadway and going over cracks and other parts of the concrete, I get that there can be pressure and stress, but that all has to be taken into consideration when you're traveling. And I'm not a mechanic kind of person. I don't know this stuff. I'm just saying, we, as drivers on the roadway, expect truckers and trucking experienced people like yourselves to know all that stuff to keep the rest of us safe. I mean, that's the whole point. Otherwise, they
Right.
wouldn't let you have it strapped down on the trailer. Do you know what I'm saying?
Yes, I do, ma'am.
Okay, so here's what it's gonna be, and I don't know if this goes to you directly or to JR Underground, but I'm just saying, it's $375 total. $375 total. There's no jail penalty, there's no probation. I'm not doing any of that, Mr. Ruckert. I just want you to be more prudent into the future so you never have the experience again. Be smarter about when you're switching trucks so you have the right authorization. That's what's expected. But safety, 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 number one. Are you with me?
I am with you, Your Honor.
All right. Thank you, Mr. Ruckert. You can disengage, but get that money into the court, you know, I'll just say by the end of the year, but in the next month or two, you should take care of that.
Thank you, Your Honor.
All right, thank you. Okay, we got a few more people connected. And let me just see, 1 second. I know that Mr. Van Hattem, you're there, and Mr. Essenmacher is there. But I need to talk to this person at the Kent County Jail for 1 second, so give me a minute if you would. Mr. Carlos Soto?
Yes.
I'm Judge Sara Smolenski. I've got your case that's D20-01982SM. The case that you have with our court, we're located at Knapp in the Beltline. Child abuse, 4th degree, allowing an unlicensed minor to operate a motor vehicle, contributing to the delinquency of a minor. The allegations that go back to July this summer, allowing a 9-year-old to drive the car, that's the allegations. The reason that you're before me now is what they're calling a bond violation. They're alleging that you had contact or tried to have contact at that address in Kent City, Oakwood Street. And I wanted to ask, are you in custody right now on anything else?
No. Oh, yes. I'm on for something different, for MDOP.
An MDOP case that you're in custody on?
Yes.
The date of this incident, the date of this alleged bond violation is September 20. How long have you been in custody?
For 17 or 18 days.
Okay. Mr. Abuxia is part of the Zoom, and I think he was representing you in the underlying charges. Is that accurate, Mr. Abuxia?
Correct, Your Honor. And he was, Mr. Soto was booked on the 3rd
Okay.
of October.
So October 3rd. The date of the incident they're saying was September 20, and it was just contact at the address on Oakwood. That's the allegation. Like with anything, Mr. Soto, it's like a new case in a way. It's not a criminal charge, but it's a bond violation. You can plead guilty or not guilty. You can have an attorney. You can talk it over and discuss the case at length. Today, we should probably just say not guilty so you can look into it further. I know that there was some allegation that you were trying to retrieve an automobile that was located at that address. You don't have to get into too much detail about what occurred on September 20, because you'll get to talk to Mr. Abuxi about that. But I just wanted to ask about the automobile in question. Since you were out and not arrested till October 3 on whatever the MDOP is, have you since got that car that you claimed was yours? Do you have that?
No, ma'am.
I'm not able to hear you.
I said, no, ma'am.
No. Okay. So tell me, Mr. Abuxia, if we just enter a plea of not guilty right now, will you be able to continue talking with the prosecutor about both this bond violation as well as the underlying 3 misdemeanors?
Yes, Your Honor. And actually, I believe, I'm not sure if the court has appointed the defender's office yet on the other case as well, this MDOP that.
Oh, I didn't know that was out of our jurisdiction. Okay, well, we'll appoint him on everything.
Yes, I'm showing that it is under the 63rd District, Your Honor, and so.
Does it show what the bond is on that
It's a-
MDOP case?
Yes, Your Honor, it's a $500 cash right now. If you're in the position to listen to
Yeah, go ahead.
bond reduction, I would say that Mr. Soto knows these no contact orders. He's well aware of what they entail, and so there is no indication that there will be further contact with any of the named individuals in the no contact order. Mr. Soto has been in there for 17 days, as he said, booked on October 3rd. I do have contact information for Mr. Soto of a 926 Franklin Street address. I do believe that if released, he will go to an address away from the listed victim's address and stay away.
Okay. Mr. Soto, I got a couple of different things here. The MDOP case is a $500 cash bond. That's what Mr. Abuxia was just talking about, hoping I'd reduce it. Then I got to set the bond on the current bond violation case, where you were on bond, still entering a plea of not guilty on all the charges with this 9-year-old child. I honestly don't know the details, except reading the face of the complaint. The allegation is that a 9-year-old child was allowed to drive a car. I don't know the details of that, but it sounds like that's where these charges stem from. As the court ordered no contact with that 9-year-old, the court also ordered no contact with her mother and ordered no contact with the address they live at, Oakwood up in Kent City. That's where the September 20 case comes into play, where they're alleging a bond violation occurred where you're present at that location. I don't know the details of that, but that's where the allegation is. So normally, go ahead.
Your Honor, if I may, at that time on September 20th, there was not a condition of bond to stay away from the mother. I do believe that at that time, the only condition was to stay away from the daughter.
Address and the daughter?
Yes, Your Honor.
Okay, I may have misspoken then. If it was just no contact with the daughter or the address, the allegation remains that you were at the address, not necessarily in the house, but at the address. That's when they're talking about the September 20. But what I was trying to explain was, I issue a bond for the bond violation, as well as knowing that the MDOP is already a $500 cash. What were you going to ask, Mr. Soto?
No, I was just gonna say, the mother had bonded me out for that.
Okay, so the mother wasn't part of it. My apologies for saying it incorrectly, but it sounds like the address and the daughter. I don't know if it's the daughter of that mother or if it's your daughter. I don't know whose daughter it is, but at any rate, I'm gonna do a $300 cash on the bond violation and keep the other one the way it is. So to get out, just on our cases, it'll be 800 total. We'll still say not guilty on everything.
You've already
Okay.
gave the bond violation.
Okay, if you've already bonded on one, then that's fine. Then it's just this new one. Okay, that's it. Make sure you follow the rules exact. We'll set it up from there, Mr. Abuxia. Thank you for your courtesy.
Thank you, Your Honor.
Okay, Mr. Essenmacher, thanks for waiting. I know you've been waiting quite a bit here. We have Mr. Van Hattem on the record. Whoops. I probably want to give me a whole new one. I'm double tasking here, double duty. Okay, so Mr. Jeff Van Hattem is the attorney for the plaintiff. That's their law firm. And Mr. Essenmacher, you're the defendant. And it looks like what this was originally a lawsuit where the law firm, Mr. Essenmacher, was trying to collect unpaid attorney fees. And then in that lawsuit, there was some discovery that was being done. I'm suggesting, Mr. Essenmacher, I don't know this, you can tell me. You're getting advice from somebody, or you're getting this
attorney, Your
idea.
Honor.
Okay. Do you have an attorney that's with you now?
No, I'm representing myself.
Okay. But when you talk about this case evaluation, we don't have very many lay people that bring that up. You must have gotten that from somebody or heard about it from somebody. Where
From the
did that
court
come
rules, Your
from?
Honor. I got
Just
it from the court.
rules?
Yes.
Okay, all right, that's fine. So when you're asking for your motion for discovery and requesting case evaluation, why don't you just state what your position is, and then I'll let Mr. Van Hattem speak?
The position on the whole entire case? Or for the
No,
discovery?
on your motion.
Okay, sorry. On the motion for discovery, there is two issues. The scope of discovery is the first one. The plaintiff has stated in its response that I've only looked to see the file itself. And what I actually am requesting is production, and you can look at paragraph 3 in my motion. I'm looking for information that should be in the file, but may or may not be. I'm looking for the information, not to look at the file itself. I don't know what's in the file. I want the information that should be in the file, and I've listed it in the paragraph 3 for my discovery request.
The ABCDE part?
Yes.
Okay.
Which is narrowly tailored, in my opinion, to
Well,
gather.
doesn't it say the entire legal file?
It's only a 3-month case, Your Honor, so it's only maybe 200
Well,
pages.
whatever, I don't care how big it is or how little it is. Aren't you under that paragraph 3 requesting the legal file?
Yes, but I'm also asking that the file include the other information.
Okay. Did you actually get the file?
No,
You haven't gotten it yet?
no.
Okay. So when you say the other information, like all research, memos, notes, records, timesheets, that kind of thing?
Communications, yes, all that is
Okay.
all.
And somehow, if you haven't seen the file and you don't know whether it's all there or not, you're thinking it could be something that's beyond the file.
Correct, Your Honor.
Okay. All right, what else?
And the second point of the discovery is that it's a time, place, and manner that should be reasonable. Well, Mr. Van Hattem, the plaintiff, has requested that I come to his office and bring a copier. And in this era of COVID, I don't think that's reasonable. I think what a more reasonable thing would be Mr. Van Hattem would gather up the information, send it to it, drop it off at a copy place. I could pick it up and pay for it, and then I wouldn't have to sit down at his office with a copier for an extended period of time. Again, with this COVID and this other stuff going on, and I think that's a much more reasonable scenario. And also, then the plaintiff can also certify that all the documents and the information requested in his control and command are produced to the defendant. If the defendant just goes down there to look at the file, I'm not sure what's in it, and I'm not sure that all the information that is requested is being produced at that time.
Okay. Mr. Van Hattem, go ahead.
Yes, thank you, Your Honor. When Mr. Essenmacher requested to look at the file and broke it down into categories, I answered yes, come look at the file. That's exactly what the court rules provide. Mr. Essenmacher is in fact a licensed attorney in Michigan. That's why he seems to know a lot. He does know a lot, and he certainly knows that the court rules are where you look to determine what the rules of the game are. And the court rules say, produce the file for inspection. They don't say deliver it to defendant. They don't say I have to copy it. If he had called and said he wants to make arrangements for a copy company to come pick it up and bring it back, I'm happy with that. I've been totally cooperative and said, look at the file. If he's saying that he thinks there's something not in the file, I can't imagine what that would be. The entire file certainly includes all of our billing records, our research done in the case, any pleadings produced. It includes everything. What would there be outside of the file?
What was the essence of the representation?
Well, it involved it was somewhat convoluted and complex because Mr. Essenmacher was a partner with another gentleman in a cigar store in Grand Rapids. And
okay, so it wasn't a divorce or anything like that. It was a commercial civil litigation having to do with business issues.
Exactly, yes.
Okay, what are we talking about in terms of the size of the file? Pages
I've got it right
wide.
here. It's, or no, I don't have the back of it. It's pretty thick. It's probably 2 to 3 inches thick. It's got, hundreds of pages.
Uh-huh.
And like I said,
And what happens when a copy company, makes a copy of it? There's a bill for it, of course, but, are you suggesting, Mr. Van Hattem, that some copy company take the file, make a copy of it, and get it to Mr. Essenmacher?
Yeah, if Mr. Essenmacher wants to arrange for that, he didn't suggest that earlier. He seems to be suggesting that today, but I've been totally cooperative and
Yeah, I
saying,
get that.
look at the file however you want to. Come to my office, take pictures with your phone. There's certainly no COVID risk. We'd all be masked and we can keep 50 feet from him and let him come in and look at it. But it's just kind of crazy that I even had to respond to a motion because I said, yes, you can,
Right.
it's a district court case. I could have said, no, we don't have an order for discovery, but I said,
Well, we've got the request
yes.
for case evaluation too, and, that's kind of part of his motion, but let me ask you this, if I can, Mr. Essenbacher.
Yes.
If your concern is COVID, which is realistic, it's everywhere, is your position that you're unwilling to pay to have the file duplicated?
Oh, not at all. I'm willing to pay for it right away.
Okay. Here's what we're gonna do then, gentlemen. I wanna have the file copied. Somehow, some way, and Mr. Essenmacher is gonna pay for having the file copied. I don't wanna get into the nitty-gritty of this, but if you make the copy at your own law firm, and it's 7 cents a copy, I have no idea what it is. I don't know if this is something that has to go to a professional commercial printer shop. I doubt it. We have police reports here that are 300 pages, and they are so thick that we have to make new binders for them. And we make those copies right here at our court when they come across from the sheriff's department or whatever. So I'm just saying, I've seen 300 pages be filed off of one of our printer machines downstairs. If that can be done, great. If it can't be done by your office, Mr. Van Hattem, I'd want you to take it to a place that can make a copy of it and, keep the bill. And Mr. Essenbacher, I'm going to order that he pay that bill. I'm not ordering case evaluation. So that part of the motion is denied. And the only part of the motion for discovery that I'm really granting, Mr. Essenmacher, is I'm granting you to get the physical copy of the file. Once you've had a chance to examine it, review it, look it over, then you can decide. But when you say to me, look at paragraph 3, paragraph A, B, C, D, E, F, I'm not going through it like that to say, well, did they give you all the research they did, or did they do other research that's not in the file? You can bring that up if it gets to be that point of a dispute. Today, it's granting in part physical copy of the file with the expense of copying to you, Mr. Essenbacher, and denial of the case evaluation. Okay, do you get it?
Yes, thank you, Your Honor.
You prepare the order, Mr. Essenmacher, and file it under the 7-day rule. And I get, Mr. Van Hattem, that you believed you were cooperating from the get-go. Just follow through with what the court said here. Should be a good deal.
Thank you, Your Honor.
Okay.
All right, thank you.
Thank you, Your Honor.
Thank you, Mr. Van Hattem. Thank you,
have a
Mr.
good day.
Essenmacher. Thanks for waiting, Mr. Essenmacher.
Thank you. Good
On the
luck.
telephone that's zoomed in, can you identify yourself?
Nicholas?
Okay, hold on, Mr. Nicholas. We're not quite to your case yet. We'll be there quickly. Mr. Abuxia?
Yes, Your Honor.
Did you have a question on a case?
No, Your Honor, that gentleman that dialed in to the courtroom by mistake earlier, Mr. Torres, we were wondering if the court had time to enter a guilty plea at this time.
Yeah, I can. We'll grab the file and we'll get to you here in short order.
Thank you. That's Mr. Torres, D200 2281 SM.
Okay. All right. Thanks so much.
Thank you.
Uh-huh. Okay. Mr. Nicholas, is your attorney on the line? No, you're just handling it yourself?
Correct.
And then Mr. Wilcox, what case are you on? Todd Wilcox? Okay, Mr. Fabian, what case are you on?
Good morning, Your Honor. I'm here today on behalf of Mr. Stanley to cover the other masters.
Okay. Tell me again? I think that's a pretrial with Mr. Tarango.
Yes, that's
And you'll
accurate.
want, is that correct?
Yes, Your Honor.
Okay, so have you already had your pretrial?
No, Your Honor. I've sent a couple of emails, but no response yet.
Okay, let me give you the number to zoom into him, Mr. Fabian.
Okay. Yes, please. Thank you.
Uh-huh.
Ready.
It's 245-899-6670.
Thank you, Your Honor. I'll do that.
Okay,
Appreciate it.
did you get the info on the Soto case, Amanda?
Yeah, and then, the Wilcox is also pretrial,
Mr. Wilcox hasn't responded, so I don't know what that is. I mean, we can if there's a file, but I got to get it. All right, Mr. Abuxia, when is Mr. Torres coming in?
He was supposed to be dialing in right after we left the prosecutor's office. I'm not sure if he's in a waiting room now or.
Okay.
He was under iPhone. It was listed under iPhone.
Mr. Torres, can you hear me right now? No. There is an iPhone that's waiting to come in. What was the charge, Mr. Abuxia?
It's a domestic violence, Your Honor.
And is it going to go under 7694A?
No, Your Honor. It is a domestic violence. Recommendation is no jail recommendation with 36 days credit for time served.
Oh, okay. Mr. Torres, can you hear me?
Yes, I can.
Okay, now I see you. Mr. Torres, it's Judge Smolenski again talking to you with Mr. Malud Abuxia on your file when you were charged with the domestic violence case. Mr. Abuxia has had a chance to talk with you and to talk with the prosecutor. And the recommendation is that if you go forward on a domestic violence plea, they'd recommend no jail, credit for the time you've already done, which is over a month. Thanks
Yes.
so much. Do you understand so far, Mr. Torres?
Yes, ma'am.
We're going back to September 3rd with this Rebecca Wilson at the address on 76th Street. And Mr. Torres, your district court case number is D200-2281-SM, and you have the right to plead guilty or not guilty. You have the right to have a trial in front of a judge or a jury. You have the right to have an attorney. And Mr. Abuxia is here and more than capable of representing you, but you have to make your own decision. If you go forward today, there will be no trial, and you give up your rights that are associated with having a trial, like bringing in witnesses, cross-examine witnesses, take the stand yourself, be a witness if you wanted to. If you chose not to, your silence cannot be held against you, and you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. Any questions so far?
No, ma'am.
Okay. So, Mr. Torres, if you go forward on this case, the decision that you make has to be yours. You get that?
Yes, ma'am.
If there was anything you wanted to appeal or anything you wanted to question, you'd have 3 weeks after being sentenced, 3 weeks to appeal to the higher court. Do you understand that?
Yes, ma'am.
So let's go back in time to September 3, to the incident on 76th Street in Byron Township with Rebecca Wilson. As to the charge of domestic violence, which is the 93-day misdemeanor, up to $500 fine, how do you wish to plead to that?
I plead guilty.
Do you remember the incident?
Yes, I do, ma'am.
Who is she to you?
She was a girlfriend I was dating at the time.
Do you guys have kids together?
No, we see each other's kids. We did.
Do you have kids of your own?
Yes, I do, ma'am.
How many?
3.
Ages? Roughly.
17, 15, and 13.
And what about the ages of her kids?
Hers are 15, 13, 10, or 11 and 11.
Okay. How long did you have a dating relationship with this Rebecca Wilson? Roughly.
2 years?
Did you live together?
Yes.
And the kids would go back and forth between the other parents, fair?
Fair.
Was the address at 460 76th Street where you lived?
No, that was a gas station.
It's a gas station in that area of Byron Township?
Yes.
On September 3, describe what happened that causes you to plead guilty to domestic violence against Rebecca Wilson.
I grabbed her by her arm and pushed her against the car door.
Are you inside the car or outside the car?
Inside the car.
Is she inside or outside the car?
Inside, driver's side.
So she's driving and, well, not driving that moment, but she was the driver, you were the front seat passenger?
Correct.
Anybody else in the car?
No.
None of the kids with you?
No.
What time of day was it?
It was roughly around 11, 12 at night.
And what was the point of being at the gas station?
She picked me up late.
Why were you at the gas station?
I was walking.
Walking to go home?
Yes, from Middleville.
And when you're walking from Middleville to go home there, you call her and ask for a ride?
Several times.
So you were frustrated and upset already to have to walk that far?
Yes, ma'am.
So when you get in the car and you're getting into a verbal dispute, does it start right away?
Yes.
And when you grab her arm to put it against the door of the car, what's the point?
I was frustrated. I was mad because she should have picked me up when I got off work, and she didn't want to come get me.
So you were angry and upset, and grabbing her arm was just your showing of how frustrated you were?
Yes.
How did the police get involved, Mr. Torres?
I punched the dashboard in front of the gas station.
Yeah, so you're in the parking lot of the gas station and other people see it?
Yes.
And they see you acting bizarre and they call the police?
Yes.
So the police come and they talk to you?
Yes.
And when the police came and talked to you, did they take you into custody right then?
They did.
So with whatever frustration mounted up this whole thing of you having to walk home from work, angry at your partner, being physically violent towards her inside the car, you then proceed to stay about 36 days in jail?
Yes.
Was it worth it?
No.
I'm just trying to wonder about the whole thing, whether it was really worth it to you.
It was not.
Okay. And today you're pleading guilty by your own choice.
Yes.
You're no longer together as a couple?
No.
And you still see your own kids?
Yes.
Are you involved with the court system on any other cases?
Yes.
Do you have any cases where you're on probation or parole right now?
I am on parole right now.
Parole with the circuit court for a felony?
Yes.
Okay. Is this case with the date of the incident being September 3? Is this case going to upset your parole?
I'm doing my violations right now as we speak. I'm on tether. I'm going through domestic violence classes and anger management classes.
Okay. Okay. Well, this is what I'd like to do. First, I'll just ask you, Mr. Abuxia, whether you believe the court has complied with the court rule in terms of the taking of the plea on the domestic violence from September 3rd with Rebecca Wilson.
Yes, Your Honor.
All right. I don't want to sentence you right now because I don't know any more details of the case. I've never spoken to this Rebecca Wilson. I've never discussed the case or had any knowledge of it. You got a lot bigger fish in your frying pan right now with you being on parole than what this misdemeanor case is. But I want to make sure that we cover all bases on this and I get as much information as I can. So we'll find out more about what you're doing with your classes and counseling and everything like that. Give Ms. Wilson an opportunity to say anything she might want to say on the date of sentencing. Any questions that you have for me at all, Mr. Torres?
No.
Do the kids that you have, the 3 you told me about, have the same mother?
Yes, all 3.
And they live with that mother on and off, just like with you, right?
She's primary.
Okay. All right. Mr. Abuxia, I just want to get a new date for sentencing and we'll take it from there.
Sounds good, Your Honor.
It'll be another Zoom, Mr. Torres, so thank you for hooking up with us on Zoom. We'll do it again when we finish this case, okay?
Okay.
All right, thank you.
Yep, thank you.
Stay in contact with your attorney. He'll tell
Miss-
you when it's going to be set.
Mr. Torres, can you please give my office a call right now, 600-8245?
Hold on.
I'm sorry, Your Honor, I apologize.
That's all right.
You said
Okay, did you get that number?
600-8245.
8245?
Yep, 616-600-8245.
All right, thank you.
Thank you.
All right, thank you. You can disconnect.
Thank you, Your Honor.
Okay. Mr. Wilcox, can you hear me? Is it Steve Wood? Who's the guy that's name is Wilcox?
He's a pretrial.
Oh. Okay, Mr. Nicholas, I want to get back to you here a second. On file D19C05622SC, this is the case where Mr. Eggebin was ordered to pay you the $500.
Yes.
And Mr. Eggebin has not zoomed in today. It was set for 9:30. It's now 10 to 10. So he appealed this. I'll officially deny it. The original order stands and the case should be over. He'll have to pay you that $500 and that'll be the end of it.
Thank you, Your Honor.
All right, that's it. Thank you. I think I said the file D19C05622SC. Thank you for waiting, Mr. Nicholas. I'm sorry for the delay.
Thank you.
All right, you can disconnect. Is it Stephen Wood?
Yes, ma'am.
Can you hear me okay?
Yes, ma'am.
Mr. Wood, do you have video capacity with your equipment?
Yeah, sorry. I thought it was
That's
started.
it. That's better. Okay. I'm Judge Sara Smolenski, and I have you in front of me on this case that is operating while intoxicated. And it looks like the case occurred November 19, a year ago. They offered you an impaired. If you decided to plead to OWVI, they technically dropped the charge of OWI. So operating while visibly impaired is a lesser included alcohol-related driving offense. Are you with me?
Yes, ma'am.
Operating while visibly impaired, Mr. Wood, is up to 93 days in jail, up to $300 fine, court costs on top of that. You can plead guilty or not guilty. You can have a trial in front of a judge or a jury. You can have an attorney represent you. If you cannot afford an attorney, the court can appoint one for you. Then you pay the expense of a court-appointed attorney. You'd have the right to have a trial where you could bring in witnesses, cross-examine witnesses, take the stand yourself, be a witness if you wanted to. If you chose not to, your silence cannot be held against you. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. Any questions so far, Mr. Wood?
No, ma'am.
Are you on probation or parole?
No, ma'am.
Do you have cases in any other courts right now that are pending?
No, ma'am.
Okay. So if you go forward today, if there's anything you wanted to appeal, you're given 3 weeks after being sentenced to appeal a case to the higher court. Any questions about that, Mr. Wood?
No, ma'am.
So if we're looking at operating while visibly impaired, and we go back to November 19, a year ago, I mean, this is like 11 months ago right now, but if we go back to 68th Street and Union Avenue in Gaines Township to a charge of operating while visibly impaired, how do you want to plead?
Guilty.
Are you pleading guilty by your own decision?
Yes, ma'am.
Has anybody threatened you to plead guilty to this?
No.
Do you remember the incident way back 10, 11 months ago?
Yes.
Were you driving?
Yes.
Was anybody with you?
Yes.
How many people?
One.
In the front seat, passenger, adult?
Yes.
Where had you been, Mr. Wood? Had you been to somebody's house? Had you been to an establishment? Were you at work? Where had you been? Prior to the police getting involved, where were you?
Either friends or the bar, I don't remember.
Were you drinking alcohol?
Yes.
Whether it was at a friend's house or the bar, you were drinking alcohol with other people, correct?
Yes.
What alcohol do you remember drinking?
Whiskey.
Hard liquor.
Yeah.
Do you remember the police getting involved? Was it a car accident? Did they pull you over? What was it?
They pulled me over.
And your friend is in the front seat with you and they're talking to you, the police are talking to you, getting your driver's license, all that.
Yes, ma'am.
Do they ask you to take a breathalyzer?
Yes, ma'am.
Did you take one right there at the scene?
Yes, ma'am.
Do you remember what the result was?
2 points over.
Yeah. So when you're talking about the amount of alcohol in your system, they're saying that you were over the legal limit, correct?
Yes, ma'am.
Okay. And did you go down to the jail and take a breathalyzer down there as well?
I don't remember.
Not remembering? Do you ever remember having blood taken from your arm if they stuck a needle in you? Don't remember?
Yes, I do.
You do? So they did?
Yeah.
They took blood from you. And
Yes,
when they
ma'am.
took blood, you found out later what the report was? And it said that you were a 0.098 grams of alcohol. Mr. Wood, when you think back on this case, do you realize, even though you didn't feel like it a lot, do you realize you had too much alcohol in your system to legally drive that car?
Yes, ma'am.
And that's why you're pleading to operating while visibly impaired?
Yes, ma'am.
All we want is for people to be safe. And it's not like you're trying to cause a problem, but in a split second, we can have a real problem. Quite frankly, we have accidents all the time where people aren't even drinking, and we have fatalities even. So when alcohol is involved, it just increases the chance tremendously for something bad to happen. Do you get what I mean?
Yeah, I understand.
Have you ever had a drunk driving before?
No.
Okay. You're pleading guilty by your own decision. Nobody's making you do it, correct?
Yes, ma'am.
Okay. I don't doubt that COVID put a lot of distance into this case, and it's taken a long time to get over with. I'm going to go forward today. When the police pulled you over, there was no car accident at all, correct?
Yes, ma'am.
You went to jail for that one night and then got out the next day?
Yes.
Okay. So here's what I'm going to do. They're going to require that you get an alcohol assessment. It's required by law in every case. They're going to do it over the phone with you from a place that will set it up. I give you a 93-day suspended jail sentence. You don't serve any jail. You won't go to jail unless you mess up. Okay, well, since this arrest, you really haven't messed up, have you?
No.
And it's been almost a year.
Yes,
So I'm
ma'am.
just asking you to keep up the good work and don't mess up. You probably can get your probation done sooner than a year, since we've already been going this too long. But just follow the rules, no alcohol, no criminal activity. I mean, that goes without saying. I say that to everybody, no criminal activity. I mean, we'd like to all live that way.
All right.
$560 fine. The probation is for 1 year, but it is possible that that might terminate early if you do everything right. $360 fee for probation, $75 crime victims' right fee, and there's a fee back to the Michigan Kent County Sheriff's Department for $275. I don't give you any community service to give. I'm not gonna, now that it's a year away. I'm just gonna have you stay clean, no violations, no problems. The Secretary of State can suspend or restrict your driving privileges. They may have already done that, I don't know, but they'll talk to you about it. Questions that you have for me, Mr. Wood?
No, ma'am.
Is the address you're at still the address we have on Kenbrook?
No.
What's the address?
43, 67, 147th Avenue,
And where is it?
Holland, Michigan.
And what's the zip?
494.
We'll look it up if you don't know
All
it by heart. We'll look it up. But we got the address. Look for mail at 147th Avenue. It'll be your probation officer talking to you about what I've just said. They'll set up a payment plan on how to pay the $1,270 that you owe. And they'll set this up so that you can be a success. But you want to make sure that you don't get any more mess ups. Are you with me?
Yes, ma'am.
Okay, that's it. You can disconnect. Look for your mail. Thanks so much.
Yep.
Okay.
Have a good one.
Yep, thank you. They'll talk to you about all the rules. Yeah. Yes. Mr. Wilcox, can you hear me? Can you hear me? You. Yeah, yes, yes. Okay, can you hear me? You gotta connect to audio. Now you should be good. Can you talk? Yes, now you did it. You did it.
Thank you, Your Honor. I'm sorry about
I know
that.
you've been waiting. I've been trying to get your attention, but I've been talking to a lot of other people, and I know you've been waiting for some time, Mr. Wilcox. You have a pre-trial conference today. I don't remember the type of case you had. What was it?
It was, I believe it was DWI.
Yep. And the magistrate you saw originally, I think we just entered a plea of not guilty, and then they set it up for a pre-trial for you to talk to the prosecutor. That's who you're going to talk. That's who you're going to talk to today. So if you have a pen, get a pen. I got to give you a number to call.
Okay, hold on.
Your audio's coming in and out. So tell me if you can get this. 245 899 6670. And Mr. Wilcox, the password would be the same password you used to get into this one with me. Now don't say it out loud because we're live streaming.
Okay.
But you want to get into the prosecutor's Zoom room, and that's 245 899 6670. His name is Felix Tarango. Tarango. We'll tell him you've been with us for 20 minutes, half hour. I'll tell him you've been with me. But you're going to talk to him on your OWI. Okay?
Okay.
All right.
Thank you.
Uh-huh. Is Mr. Steele part of this Zoom? Are you there?
I'm right here, Your Honor.
Now, you're going to be talking to the prosecuting attorney, Mr. Steele. Have you talked to them today?
I have not.
Okay. If you have a pen handy, I'd like you to take down this number.
Yes, Your Honor, 1 second. I'm ready.
245-899-6670. And you'd use the same password that you used with me. Don't say it out loud because we're live streaming. But you'd use the same password you used to get into my Zoom. And his name is Felix Tarango with a T, Tarango. And that's who you want to talk to about your pretrial first before you get into the Zoom with me, okay?
Yes, Your Honor.
You got it, Mr. Steele? That's good. Then just disconnect with me and connect with him.
Yes, Your Honor.
All set. Thanks a lot. I've got a telephone number on the Zoom that ends in 3895. If you can hear me, let me know. A telephone number ending in 3895. Are you with me?
Yes.
Okay, good.
We hear you.
Tell me, I can hear you too, so tell me your name.
My name is Kim Agabine. Terry's my husband. We've been on, and you dismissed it to the plaintiff, and we were here. We couldn't hear what it told us to do when you were talking to get in. So here's Terry.
Oh.
Hello?
Yeah, Mr. Agabine, can you hear me?
Yes, I can.
Yeah. When you guys, your wife just tried to explain that you were hooked up to Zoom, but we didn't know and we didn't have you part of it. There was no identification in our Zoom room, and I don't know what the mix-up was on it. And I did treat it like you weren't there, of course, but here's my question to you. What number was it that you called to get in?
Just a minute. 646-876-9923.
And the first three numbers were 946?
646.
Okay, and what exactly is that number, Mr. Agabine?
That's the audio only by phone to call in.
Oh, I see. And then what did it tell you when you were on the phone message? Or how was it? Like you're saying you've been on the phone for 35 minutes.
It asked us for the Zoom meeting ID and the password.
And then you put that in?
Yes.
Uh-huh. And then does it say anything about how you unmute yourself? On the
I don't
phone when you
remember
were
that.
talking to him. How did your wife Kim get to talking to me?
What I finally heard what it said because it was telling us what to do, giving us prompts at the same time that you were talking, and we couldn't get it.
Oh, so then when you did get the correct information, you did it, and then that opened you up to us.
Yeah.
Yeah. Okay, well, separate and apart from that, I'm not doubting it. I'm not doubting that you guys really worked hard to do this and everything else. What I wanted to find out was, whatever happened with your attorney?
What happened with the attorney? I'm not understanding the question.
Well, this was a small claims case that was a small claims where the other guy sued you. And then in small claims, you got an attorney and then removed it to the general civil docket. Did
That
you
is
have
correct.
an attorney?
I did.
So my question is, what was that McCarger?
Say that again, please.
Was the attorney McCarger?
Was the attorney what?
I'm sorry, I couldn't understand it.
Okay. When you got the attorney to help you, Can you hear that or can you not hear me?
Yes.
Wasn't the attorney that you got to help you, his name was McCarger?
Oh, McCarger, yes.
Yeah, that's what I've been saying.
Yes,
And
I'm
my
sorry.
question originally, don't need to be sorry, Mr. Agabin. I get that it's frustrating just to even have to be here. My original question was, what happened with your attorney? Like,
Well,
why
the
am I
case
just
went-
talking to you?
Why are you just talking to me?
Yeah, where's Mr. McCarger?
Well, he's not here. I'm at home.
Yeah, I get it. But he never zoomed in either. Is he representing you or is he not?
No, he is not representing me today.
Right, so you're just handling it yourself.
That is correct.
So when he was representing you, in the end, the result was you had to pay the deductible.
At the first small claims hearing, yes, I was. Yep,
That's what you were appealing.
that is correct.
Yeah. Okay. So my question still remains, whatever happened with the attorneys? Did you guys just stop using the attorneys?
Yes, because that's being small claims, you can't use an attorney, right?
Yeah, but at some point it got removed out of small claims, didn't it?
It got bumped up to civil, and then it was sent to mediation, and then during mediation, we agreed to go back to small claims.
Oh, okay, that helps me understand it. Yeah. Right. Well, I don't have a problem with the fact that you tried to connect and it didn't work. That's a hassle, no doubt.
Well, we
But
were
I'm really-
connected.
Right,
We
you
could
could
hear
hear,
you.
but you just couldn't, right. But because you were muted and we couldn't hear you, we didn't have any idea that you were there. It just shows up that you're in the courtroom. I mean, it doesn't have your name or anything like that.
Oh,
Yeah, it's like people that would walk in and sit in the courtroom. I don't know who they are. They're just sitting there watching. So this
Well,
is
I
live
typed-
streaming. This is
I typed my
live.
name in.
Yeah. So they have you type it in,
Yeah, I typed it
like
in.
on the phone, like on the phone.
Not on the phone. No, we left and went home, and I'm on the computer, and I typed it in and entered the meeting.
Oh, no doubt it's a hassle. I don't want to be the bearer of bad news, but I am. And as frustrating as this whole thing has started from the very get-go in the parking lot of Andrea's or whatever you were talking about,
Yeah.
well, how frustrating this whole thing is from the very get-go. And I mean, maybe when you were talking with your attorney at the time, it was in civil. You want your day in court, but then you decide to go to small claims. Both sides get rid of attorneys, go to small claims. The magistrate hears it. You were frustrated still then, thought it was unfair, appeal it. Then you get jammed up in this, like getting a flat tire on the way to the court or something. I mean, I get that you made an effort, but I'm the bearer of bad news because basically the original judgment's going to stand.
Okay. Well, unfortunately, the notice that I was sent to appear says to appear at the courtroom. There was no Zoom information included in the letter.
Uh-huh.
So we were.
So could you have come to the courtroom? Could you have come to the courtroom?
We were
Today you
there
were
this
here?
morning at 9:15.
So what happened?
And we went up. We went inside, and she said, "Well, this is by Zoom." She gave us the Zoom information. We went out to the parking lot, called in. We could hear what was going on. Then we decided, well, we'll just drive home a minute, and I'll go log on and do it on the computer. And so that's how it went.
Huh. Yeah, I
I mean,
didn't
we heard you
realize you were
talking.
physically downstairs because the building is open. You could have come up.
She told us not to. She told
Yeah,
us to go out and,
I'm sure that's the case. Well, let me do this. Let me just find out if I can, well, why don't you do this? Why don't you just tell me what your basic appeal is? What is your appeal? You think it was
Well,
as
that
much
this-
his fault as your fault?
well, initially we thought that it was an accident at Andrea's Pizza. And then we come to find out much later, months, like 6 months later, that he claimed that it was with another vehicle that is in my name in a different location. And so the whole thing was mixed up from the beginning.
Somehow, even right now, you're coming in and out audio. I don't know if you're moving your face or away from the phone. You're just on a regular phone, aren't you?
Yes.
Yeah. Okay, but the audio, I can hear your wife in the background too, but I'm just saying, you go in and then you go out. I'm catching what you're saying.
Okay,
Is the
can you hear me
point of
better
it
now?
Yes, I can hear you. Is the point of it that where he claims the accident was, you were never even there?
That is correct.
So the Andreas is what you thought all along, and it wasn't that at all. And you think
Right.
he's like got the wrong license plate?
I have no idea how this all came about because we don't live anywhere near Ada. It's my wife's car. She has a GPS on her phone that shows she wasn't anywhere in that area at the time.
Did you ever get to talk to the police?
I did talk to the police, yes.
And you never got a ticket,
No, I did not.
right? And you told the police everything that you had to say?
I did.
Yeah. And then the next thing you know, the small claims happens.
Right.
Okay. So really, your whole point is, it's not about the accident, it's that it wasn't your car, it wasn't you.
Well, no, it wasn't our car. There was never any damage to our car. How could there be $1,800?
No, I'm not talking about damage. I'm not talking about damage to your car. You're saying your vehicle or one of you or your family or your friends were not there. It was not you.
That is correct. It never happened.
But somehow you got it mixed up because you bumped cars with some guy in Andrea's Pizza and you were putting 2 to 2 together thinking it was that incident, which turned out to be nothing and it wasn't even that guy.
Well, that's, yeah. I mean,
Is that how you, and then,
yes.
yeah, okay. And then when you told the magistrate, you went through that whole thing.
No, we didn't get into any of that hardly at all until the very end. It was brought up about the confusion about the accident with what vehicle and where it happened.
You mean the whole time you're going through the hearing with the magistrate, you're thinking it's Andrea's Pizza parking lot and the other people are thinking?
No.
Okay.
But it took us 6 months to find out where the accident happened and with what vehicle. After we got the initial letter from his lawyer, Wardrop, we didn't have any information, and so we thought, what accident? And then I remembered I had a little bump in the parking lot, so I thought, well, that must be it.
Oh,
and
I see.
So 6 months later, we finally find out, no, that wasn't it. It was with a different vehicle at a different location. So there was a lot of confusion.
Okay. Is Dickinson still the address you're at?
Yes.
And you can get mail there?
Yes, we can.
Okay. Let me just do some checking myself and I'll send a letter out. I mean, obviously the other guy, Nicholas, I think his last name was Nicholas or Nichols or something like that. You heard everything that went on this morning because we thought you weren't here. I had no knowledge that you checked in downstairs. I had no knowledge you were trying to get on the Zoom, telephone only, that you went home. I mean, if you would have been able to listen, like your wife said, without the interruption of everybody talking, of course, we had 10 cases, and you didn't know how to unmute yourself, we would have been able to know, because then it shows, that you're in the meeting room, but it never showed that you were in the meeting room. Even if it's not your name, it's a number, and it can say a number, and I'll say to a person, if your number ends in such and such, well, like I did with you guys, I think. But anyways, let me look into it and find out, because the magistrate, what part bugs me the most, I guess, is if your position is, this was never you, never your car, never your accident, why wasn't that told to the magistrate from the very get-go? That'd be the whole basis of your case.
It was told.
But you said you never got to it till the very end.
I never got to the part about the whole thing that happened at Andrea's Pizza.
Yeah, but Andrea's Pizza would have nothing to do with it, would it? Because that's not even what you're talking about.
No, and I didn't bring it up. Mr. Nicholas brought it up.
Uh-huh. Yeah.
And then the magistrate asked me about it, and I told him what had happened and that how we thought that was.
How would Nicholas bring up the accident in Andrea's Pizza? How would he even know about it?
Because of correspondence between our lawyer and his lawyer on what had taken place.
Oh, uh-huh. Just a separate incident. But
Yes.
from the very get-go with the magistrate, you're saying that from the very get-go, with wherever Mr. Nicholas said this was, you were saying from the very get-go, it wasn't you, it wasn't your car, you weren't there.
Right.
Yeah. Yeah, that's as weird can be. Did you ever talk to your insurance carrier, or did your insurance carrier never get involved?
No, my insurance company never became involved. I mean, there was nothing to report.
Normally they won't. Right. Uh-huh. All right. Well, let me do some checking and I'll find out. I'm sorry for what happened this morning downstairs, because that's just buggy. But we're living in a bit of an uncertain time with this COVID. Are they people coming in by Zoom? Are they coming in? We've only been physically open to the public for probably 2 weeks in the last 7 months.
Okay, well, part of the problem was the letter I received tells me to appear, and there was no information about any Zoom meeting or anything. It says here you are directed to appear at the address above.
And what was the date? Right, and you did that. What was the date of that letter?
The date of the letter, 9/16.
Yeah. Okay. All right. Well, let me look into it. At least I've been able to hear what your side of the appeal was. That's really what I wanted to know. But I will let you know what's going to transpire from here. I'm not really positive what's going to happen, but I think it's frustrating that, you showed up downstairs. Frustrating to you, frustrating to me too, because they could have just let you come upstairs. I probably had 10 or 12 cases going, and it was busy, and that doesn't excuse anything. But we never saw anything that you were, connected. So it's not unusual for us to not, to have no-shows. We have no-shows all the time. Anyway, let me look into it, okay?
Okay.
All right, thank you.
All right.
We've got info. We'll get back to you. Look for your mail.
Okay.
Thank you,
All right,
Mr.
thank
Eggman.
you.
Uh-huh.
All right, bye.
Uh-huh. What was the last name? Mr. Van Hatten, are you still on? Is there anybody on Zoom that can identify themselves? You can just disconnect.